As you will see in the program, Dr. Berkowitz earned a bachelor's in English literature from Swarthmore, an MA in philosophy from the Hebrew University of Jerusalem, and a JD and a PhD from Yale. Since that time, he's held a variety of academic positions. He taught political philosophy at Harvard University from 1990 to 1999. He also taught constitutional law at George Mason from 1999 to 2007, and now he is a senior fellow at the Hoover Institution at Stanford University. He has written books on a variety of topics, ranging from academic political philosophy, a book entitled Virtue in the Making of Modern Liberalism, and he's also written a book, Nietzsche, the Ethics of an Immoralist. Now he also writes books about contemporary American social thought, with two recent separate books about the primary competing political schools of thought in our day, conservatism and progressivism. His latest book is entitled Constitutional Conservatism, Liberty, Self-Government, and Political Moderation. Certainly a topic we all need to think seriously about in an age where there seems, unfortunately, to be a lack of political moderation, indeed where moderation is sometimes seen as a vice rather than the virtue it is. Baylor students will be particularly well prepared for this book because, as Dr. Berkowitz might be pleased to know, Baylor has a requirement that every student take a course in American constitutional law. Incidentally, Professor Berkowitz has also written a great deal about the state of contemporary universities and about the idea of liberal education in particular, something we at Baylor here also value highly. But in the midst of all this scholarly output, Dr. Berkowitz has also written a huge number of shorter pieces in outlets such as the Wall Street Journal, Real Clear Politics, the Weekly Standard, Commentary Magazine, and many others. He is, in the best sense, a public intellectual, someone who takes ideas seriously and presents complicated matters in ways that are accessible to all of us. As he put it in conversation last night, he said, "I have to realize that people are picking up their Wall Street journals and reading my essays over coffee as they're just waking up." And the implication of this, of course, is that he must meet the challenge of being both engaging and substantive, and he is. This is what I imagine Laura Jackson would have approved and wanted. His topic tonight is remarkably timely, since, as many of us know, President Obama has just made his first trip to Israel as president, where, among other things, he's been discussing matters that I am certain will intersect with Dr. Berkowitz's reflections tonight. The title of Dr. Berkowitz's talk is Israel and the Struggle Over the International Laws of War. Let us welcome Dr. Peter Berkowitz.
First off, thank you for the warm introduction. It's wonderful to be here at Baylor. I want to thank the Jackson family for this opportunity, thanks to Dean Tom Hibbs, whom I received the initial invitation, and it's wonderful to see here an old friend, Ken Starr. It's great to be here. In my prepared remarks, I'm not going to talk directly about President Obama's visit to Israel, but I'll be delighted during the question period, if you'd like, to offer a few thoughts on the President's visit. Tonight, what I want to talk to you about is the title of the talk, Israel and the Struggle Over the International Laws of War. I'm going to begin with some general remarks about international law and the phenomenon of lawfare. I'll explain that. And I'm going to concentrate on the controversy over the Goldstone Report. It may have already faded from memory, but I'll remind you what the Goldstone Report was, talk a bit about the great damage it caused to Israel, and also stress the implications of the struggle over Israel and the struggle over the international laws of war for the United States, because we, the United States, are implicated in that same struggle. And I'll conclude with some general remarks about what steps we need to take to deal better with the problem of the international laws of war. Why are the international laws of war so interesting these days, so important? In the 1830s, Tocqueville, Frenchman, wrote what is still probably the greatest book about American democracy, Democracy in America. And in that book, Tocqueville makes well, Tocqueville makes thousands of interesting observations. Among the thousands of interesting observations he makes is this: in America, all great political questions seem eventually to get turned into legal questions. All great political questions seem to get turned into legal questions. Why that is for another evening, but it's a phenomenon that happens, he thought. What I want to suggest tonight is that what Tocqueville said was true about political questions within American democracy has now become true of political, diplomatic, and national security questions on the international stage. These questions, political, legal, national security questions on the international stage, are increasingly turned into legal questions. Therefore, if we wish, in our case, to defend the United States, to defend our allies, political matters, diplomatic matters, national security matters on the international stage, we have to be prepared to understand the legal issues, the legal framing of the issues, and respond to the legal challenges. It's a matter of fact, an observation, that the international law increasingly provides the language in which Western-trained intellectuals and political elites talk about war and peace. More and more, the language of international law, whether we approve or disapprove, influences public discourse and public opinion. And in a democracy, public discourse and public opinion significantly influences the range of strategic options. Therefore, if we're going to justify, for example, America's use of military force to a skeptical and sometimes hostile world, or in Israel, if they're going to explain and justify their conduct in war to a skeptical and sometimes hostile world, it's simply become necessary to master the language of international law in general and the international laws of war in particular. So I want to say something about the history of my interest in this question. My concern about the international laws of war grew out of work I had been doing at the Hoover Institution on the problem of laws of war. We formed a task force at Hoover 2006, 2007, and the task force was formed in the wake of the September 11th attacks on the United States by Al-Qaeda. Why would those attacks generate a need for a task force on national security and law? Our aim was to examine and provide answers to the novel and difficult legal questions that emerged in the fight against international terrorism and Islamic extremism. For the United States, puzzles arose because neither U.S. criminal law nor the international laws of war provided clear standards, clear procedures, clear directives about how to deal with terrorists. What's a terrorist? There's a huge controversy over this, but we can define, as a first approximation, pretty clearly what a terrorist is. Terrorists engage in acts that threaten a community's territorial integrity and political sovereignty. So they're more than mere criminals, more than people who rob banks or even commit assaults. But terrorists are different from ordinary soldiers. A terrorist doesn't carry his weapon openly. A terrorist doesn't wear a uniform. A terrorist does not fight as a soldier of a regular army of a recognized state. And they aim their attacks at civilians and its civilian infrastructure. As a result, terrorists are not entitled to the regular protections and privileges that the international laws of war give to POWs, prisoners of war. Now, on September 10th, 2001, American law was well equipped to deal with criminals. And the international laws of war were well equipped to deal with soldiers who were captured, lawful combatants. But neither body of law was well equipped to deal with terrorists, who are neither criminals, although they partake of some of the features of criminals, nor soldiers, although they partake of some of the features of soldiers. So this was the problem to which our task force was addressed. And from the beginning, our task force recognized that the case of Israel would prove instructive for us. Why is that? Well, because, as you know, since its birth in 1948, Israel has never known a moment when it wasn't under immediate threat of terrorist attack. Second, no liberal democracy has faced a more sustained assault from non-state enemies than Israel. And third, no liberal democracy has acquired greater experience in fighting terrorism under law than Israel. Our experience fighting terrorism under law really began 12 years ago, almost 12 years ago. Israel's extends to 1948. So Israel, even more than we do, stands on the front lines of a new kind of struggle, the struggle over the international laws of war. And, sad to say, Israel's terrorist enemies have used the laws of war in an attempt to criminalize Israel's right to defend itself from armed aggression. Unfortunately, many Western diplomats, human rights lawyers, and intellectuals have in effect collaborated, usually unwittingly, but sometimes out of malice. The use of law as a political weapon has come to be called lawfare, play on warfare. Now, in my opinion, the school of political thought in the United States called progressivism and the school of international relations called liberal internationalism have encouraged lawfare by seeking to oppose reckless demands on liberal democracies. That is, reckless demands on liberal democracies when they're forced to go to war. At the same time, these schools of thought encourage the reckless dream that politics and war can be replaced by rational administration. Would that it were so, but rational administration, government by technocrats and bureaucrats, is not always the answer when mortar shells, rockets, and missiles are raining down on your population year after year. Those seduced by this dream exhibit extravagant faith in the ability of diplomats and courts of law to resolve disputes among nations. And they aim to rewrite the international laws of war to aggressively reduce the range of circumstances in which states may lawfully use military force. But in doing so, they leave important factors out of the equation, factors important to consider when we're considering the important question, is it just and proper for a state to go to war, to use military force? For example, they often omit or fail to take seriously terrorist resolve and the resolve of the rogue and authoritarian states that support them to accomplish their goal by using violence of every conceivable sort against civilians. Or, to come at the matter from a slightly different angle, but the same point. The international laws of war today, as we know them, emerged out of a noble ambition. The noble ambition was to balance two important goods, or imperatives. One imperative was military necessity. Unfortunately, it happens that states confront implacable enemies that are determined to destroy them or cause great injury to them or conquer them. In those cases, they have a right to defend themselves. Sometimes the only means is military force. But the other imperative, or good, is humanitarian responsibility. Military necessity involves defeating your enemy through the use of force. Humanitarian responsibility involves setting limits on the use of force, both to protect non-combatants and in some important respects to protect combatants themselves. You can see easily that these imperatives sometimes conflict. Sometimes you could bring a military threat to an end by dropping a very big bomb, but then you would kill innocent non-combatants in the process. So, the core notion of the international laws of war is to balance these two imperatives: military necessity, humanitarian responsibility. The problem in a nutshell is that in invoking international law, many critics of Israel and of the United States overlook or seek to transform the balance mandated by the international laws of war. They do this by focusing exclusively on the claims of humanitarian responsibility. Make sure that no civilian infrastructure is in any way harmed. Make sure that no civilians are in any way touched by war. But they disregard altogether the claims of military necessity. That is the imperative of a nation-state to protect its own civilians. In doing so, by the way, many progressives overlook a nation-state's humanitarian responsibility to protect its own citizens. This evening, I'm going to discuss a particularly flagrant example of lawfare. Again, the use of law as a political weapon, namely the Goldstone Report, which was published by the United Nations in September 2009. The Goldstone Report harshly condemned Israel on the international stage for actions that Israel took to defend itself against Hamas. Again, as you know, Hamas today, and since 2007, has ruled the Gaza Strip. It openly calls for Israel's destruction, and it's declared religious war to achieve its goal, and it targets civilians as a centerpiece of its military strategy. It's also funded and equipped by Iran. Most of the legal arguments in the Goldstone Report are weak to indefensible. Unfortunately, these arguments, the ones found in this 545-page report, UN report, have become very influential, especially in Europe, especially in the United States, even actually in some precincts in Israel itself. In fact, the Goldstone Report is commonly treated at American law schools as the last word on the legality of Israel's operation in Gaza. This is bad. This is certainly bad for Israel, but it's bad for us too. It's bad for the United States as well. The legal arguments that are used to condemn Israel in the Goldstone Report, the style of thinking, are also designed to severely restrict the legitimate use of force by liberal democracies generally. And generally, and for the most part, there are only two liberal democracies in the world that on a daily basis rely on the use of their militaries. And those two armies are the armies of Israel and the United States. And another paradox I should mention here, in the entire history of warfare, I believe, there are no two armies that have devoted more time, more energy, more intellectual energy to understanding the laws of war, thinking through the laws of war, and attempting to conform their military's conduct to the imperatives of the laws of war. It's therefore a very painful irony that today the two armies that are most accused of violating the laws of war are the armies of the United States and Israel. Now, I've already have been, I will continue to be very critical of those who abuse the laws of war. So I need to emphasize, my critique of the abuses of the international laws of war should not be confused with a rejection of or disparagement of the international laws of war. To the contrary, as I just said, Israel and the United States take them very seriously. They're right, we're right, the Israelis are right to take them very seriously. Our soldiers, Israeli soldiers, take great pride in having internalized the laws of war and fighting to the best of their abilities in accordance with them. As liberal democracies, Israel and the United States respect the dignity of individuals, of all individuals, not only of their citizens, and they seek to protect the dignity of non-citizens as well. And both Israel and the United States have a vital national security interest in their enemies also respecting the international laws of war. So, I believe the international laws of war are both noble and necessary, and that the United States and Israel has an interest in protecting them. The Goldstone Report, about which I'm going to now speak, I think has undermined our American interest in them, has undermined the Israeli interest in them. So a little bit of background. Well, actually, after the Goldstone Report was published, on of all dates, April 1st, 2011, the Washington Post published a remarkable op-ed by Justice Richard Goldstone. Justice Richard Goldstone, who chaired the commission that wrote the Goldstone Report, had been a justice on the South African Constitutional Court, and he had been the chief prosecutor in the trials, the war crimes tribunals for the former Yugoslavia and for Rwanda. So he came to this report as a distinguished jurist. And on April 1st, 2011, Justice Goldstone reversed himself. The Goldstone Report's mission back in May, when it was created in April 2009, was to investigate the facts surrounding war crimes allegations arising out of Operation Cast Lead. This was Israel's December 2008, January 2009 military operation in Gaza. That campaign took place over 3 weeks. Its purpose was to stop Hamas's firing of thousands of rockets and mortar shells and missiles at Israeli civilian populations in southern Israel, every one of those firings was a war crime in itself, because it involved indiscriminate firings at civilian populations. There were no military targets. Now, following its publication in September 2009, the Goldstone Report became a kind of proof text for those around the world determined to denounce Israel as an outlaw nation. Writing in the Washington Post, in his personal capacity, he emphasized, Goldstone, on April 1st, 2011, a year and a half later, withdrew the gravest charge of the report. What was that? The Goldstone Report's gravest charge, which it presented as a legal finding, was that Israel had deliberately adopted a strategy of humiliating, wounding, and killing civilians in Gaza and destroying civilian infrastructure. In other words, none of this happened as an accident. None of this happened as a byproduct of Israel's efforts to bring to an end the firing of missiles at its civilian population. Israel's strategy was to destroy civilian infrastructure and to injure, humiliate, wound, and kill civilians. In the Washington Post, Goldstone stated that it's now well established that, I quote, civilians were not intentionally targeted as a matter of policy. In the report, he said citizens were deliberately targeted. A year and a half later, he says, oops, no, citizens were not deliberately targeted. Well, that's an enormous correction. How could Justice Goldstone, a distinguished jurist, be so gravely mistaken about so important a matter? Goldstone claimed that since publication of his report, much new information had come to light. Excuse me for saying so, but that's a preposterous explanation. Yes, new information had come to light, but there never was evidence, certainly none was presented in the Goldstone Report, sufficient to support the grotesque charge that Israel had adopted a deliberate policy of killing civilians in Gaza and destroying civilian infrastructure. No evidence. Moreover, in the Post, Goldstone failed to acknowledge that nothing had done more than his UN-endorsed report to promulgate the slander that Israel had adopted an intentionally criminal strategy. In fact, the Goldstone Report even went beyond asserting that Israel had adopted an essentially criminal strategy. It implied that Israel was worse than Hamas. Israel was worse than Hamas because Israel was a state, because Israel used state-of-the-art weaponry, and because the death and destruction Israel supposedly deliberately inflicted on civilians in Gaza was much greater than the harm to civilians in southern Israel caused by 8 years of Hamas bombardment. Goldstone's retraction on April 1st, 2011, also silently withdrew the scurrilous accusation that the Israeli legal system fell short of international standards. From the point of view of the Goldstone Report, this failure on the part of the Israeli legal system partly justified the intrusion by this UN fact-finding mission. In fact, Israel's judicial system and its procedures for investigating war crimes allegations is on a par with those of the United States, the UK, Canada, and Australia, and in some respects, it's superior. In fact, within 18 months of the Goldstone Report, Israel had already undertaken 400 separate investigations of allegations of war crimes during the Gaza operation. Now, some distinguished Israelis have argued that the important lesson for Israel to learn from Goldstone's reconsideration is that Israel ought to have cooperated with the Goldstone mission from the beginning. Israel refused to cooperate. They maintain furthermore that Israel should cooperate with similar international investigations in the future, even if the investigators are biased. They argue better for Israel to make its case and get it on record before official conclusions are published by the UN and ratified by the international community. In my view, this is the wrong lesson to learn from the Goldstone Report. Why? Because Israel should not acquiesce. Israel should not acquiesce to one set of rules and standards for Israel and another set of rules and standards for all other countries. Israel should not cooperate in the abrogation of its rights and responsibilities as a sovereign nation by encouraging UN investigations before it has completed its own investigations. In fact, such UN investigations lack foundations in international law. Under the international law of wars as written, the right and the obligation to investigate and prosecute war crimes belongs in the first place to the nation states so accused. The right and the responsibility to investigate war crimes allegations in the first place belongs to the nation states accused. Only when a country has shown itself unwilling or unable to exercise its right and discharge its responsibility are international bodies authorized to pursue war crimes investigations. I'll come back to this important point. For now, I'll emphasize that at the time that the Goldstone Commission was created and the time the Goldstone investigation was undertaken, Israel was following established procedures and in the early stages of its own investigations. In other words, Israel was still in the process of complying with its obligations under international law when the Goldstone Report was published. So what's the right lesson to learn from the Goldstone controversy? The right lesson to learn is that while Israel must continue to cultivate respect for the international laws of war at home, it must also rigorously champion a sound understanding of those laws of war abroad. Again, partly because of the Tocquevillian point. There's no changing the dynamic whereby, in our world increasingly, political questions, diplomatic questions, national security questions are debated in the language of law. So, where's a good place to begin? I think a good place to begin is with the Goldstone Report, which has done so much damage and has fostered so many dangerous misunderstandings. Perhaps the biggest misunderstanding about the international laws of war is embodied in the Goldstone Report's assumption that harm to civilians in war is prima facie evidence of criminal conduct. Again, this assumption, harm to civilians is prima facie evidence of a war crime, or at least a war crime by the invading army. In fact, because there was indeed harm to civilians, there was indeed harm to civilian infrastructure in the Gaza operation, many people assumed that Israel was therefore obviously guilty of war crimes. Here's an example of such a view. This comes from Naomi Klein, who wrote the introduction to a book of essays about the Goldstone Report, published also in 2011. Klein, a journalist, begins as follows. A sprawling crime scene. That is what Gaza felt like when I visited in the summer of 2009, 6 months after the Israeli attack. Evidence of criminality was everywhere. By the way, this is 6 months after the operation. Evidence of criminality was everywhere. The homes and schools that lay in rubble. The walls burned pitch black by white phosphorus. The children's bodies still unhealed for lack of medical care. Now, was Klein right? Was evidence of criminality everywhere, even in her painful descriptions? Well, certainly evidence of violence, destruction, and civilian suffering, yes. But evidence of crime. Let me quote here from Luis Moreno Ocampo, who was the chief prosecutor for many years of the International Criminal Court. He writes, and I quote, "Under international humanitarian law and the Rome Statute, which created the ICC, the International Criminal Court, the death of civilians during an armed conflict, no matter how grave and regrettable, does not in itself constitute a war crime." Another way of saying it, a proportionate attack against legitimate military objectives that results in civilian injury or death, however tragic, are legal under the international laws of war. The attack must be proportionate, must be against a legitimate military objective. We'll come back to proportionality. As I've mentioned, the Goldstone Report's gravest finding, the takeaway heard around the world, was that the strategy guiding Israel's Gaza operation, the very strategy, the rules of engagement, the very strategy was unlawful. The report did not deny the legitimacy of Israel's purpose in Operation Cast Lead. The purpose was stopping the firing of, as I've mentioned, the thousands of mortars, rockets, and missiles at Israeli civilian populations. Nevertheless, the Goldstone Report that Israel launched, now I'm quoting from the Goldstone Report, a deliberately disproportionate attack designed to punish, humiliate, and terrorize the civilian population, radically diminish its local economic capacity both to work and to provide for itself, and to force upon it in an ever-increasing sense of dependency and vulnerability. In October 2009, a month after the report was published, Justice Goldstone publicly acknowledged the following, I quote, "If this was a court of law, there would have been nothing proven." If this was a court of law, there would have been nothing proven. Actually, he's right. 545-page report proves none of this, especially this outrageous charge that Israel's strategy was essentially criminal. Nothing would have been proven. But I assure you, that's not how the Goldstone Report reads or was read. It is read as having established, beyond the shadow of a doubt, Israel's war crimes and crimes against humanity. Now, in my view, its legal findings should be rejected. They should be rejected not because Israel made no mistakes in the Gaza operation. Of course it made mistakes. All countries at war make mistakes. But again, Israel is not charged with individual soldiers or commanders making mistakes. The accusation was its very strategy was criminal. Here, briefly, 4 fundamental flaws with the Goldstone Report. 1, the report gathered and analyzed evidence improperly. It largely relied on the testimony of Palestinians in Gaza Strip without ever taking into account the fact that the Palestinians who testified live under a totalitarian dictatorship, and so were not free to offer their real opinions about what was going on. At the same time, the report gathered no evidence from Israeli soldiers or commanders because Israel declined to cooperate. And as I said before, Israel was under no obligation to cooperate. But here was the problem for the Goldstone Report. The report's legal findings turned on factual findings about the intentions in battle of Israeli commanders and soldiers. So the Goldstone Report was missing crucial facts and only on the basis of those facts could it reach the legal findings that it reached, but it lacked those facts. And as I said, Israel had no obligation under international law to cooperate. And I should add, Israel had plenty of reason, amply confirmed by the Goldstone Report's many fundamental and fatal flaws. Israel had ample reason to suspect any undertaking initiated by the incurably compromised United Nations Human Rights Council. This was the General Assembly body that actually authorized the report. But the main point, let me emphasize the main point. Without access to legally decisive facts about the understandings and intentions of Israeli commanders and soldiers, the Goldstone Report's legal findings were worthless. We'll come back to this in a moment, some remarks about the principles of distinction proportionality. Second, the Goldstone Report failed to accurately characterize Hamas. The report ignored or downplayed Hamas's ideology and charter, which, as you know, call for Israel's destruction. The report ignores or downplays Hamas's overall terrorist strategy, its enforced Islamization of Gaza, and the constant flow from Iraq through Egypt's Sinai Peninsula into Gaza of rockets and missiles for attacking Israeli civilians. As a result, the report was incapable of properly weighing Israel's claims of military necessity. Third, and closely related to the first two, and this is really actually quite amazing given that the Goldstone Report, under the supervision of Justice Goldstone, was under the supervision of a first-rate legal mind. Nevertheless, the Goldstone Report systematically misapplies the principles of distinction and the principles of proportionality. These are the very cornerstones of international laws of war covering conduct in battle. They may sound formidable, but they're not. They crystallize, I think, what many of us share as common sense understandings of the principles that should govern conduct in war. Let's take the principle of distinction first. The principle of distinction requires combatants to distinguish fighters and military objects on the one hand, from civilians and civilian objects, or non-combatants and civilian objects. And having distinguished them, the principle of distinction requires you to target only fighters and to target only legitimate military objectives. But by the way, the principle of distinction, this is very important, hardly mentioned by Goldstone, the principle of distinction also requires combatants to distinguish themselves from civilians. That's why combatants wear uniforms, carry their arms openly, and they don't hide in civilian areas. None of these requirements were observed by Hamas. Now, that the principle of distinction can be easily stated doesn't mean that it can be easily applied as a test. As you can imagine, Israeli commanders and soldiers faced extremely difficult targeting decisions. Why is that? Because Hamas fighters flagrantly violated their part of the principle of distinction. That is, they're obligated as fighters to distinguish themselves from their civilian population. Instead, the Hamas fighters dressed as civilians. They hid weapons in and around homes, schools, hospitals, and mosques. They booby-trapped neighborhoods, and they targeted Israeli civilians. Now, there is a legal test to determine whether the principle of distinction has been honored. The question goes something like this: whether a reasonable combatant in the actual circumstances would believe that the target in question is being used to make an effective contribution to military action. Is it a legitimate military objective? Is it reasonable to think that that's a legitimate military objective, target? But notice this test requires you to have some facts about what soldiers and commanders were thinking. As I mentioned, the Goldstone Report failed to obtain legally decisive information about the understandings and intentions of Israeli combatants. This is highly relevant because under the laws of war, operating in civilian areas causes those objects to lose their immunity. That is, when you're thinking through Israeli targeting decisions, or go back to Naomi Klein's description of a criminal area, not the mere fact of violence, but from the point of view of whether the international laws of war have been honored, those civilian areas lose vulnerability as soon as fighters place themselves there, in them. In sum, the Goldstone Report disregarded or suppressed information about Hamas's intentions and conduct, and the Goldstone Report lacked vital information about Israeli commanders and soldiers' intentions and understandings. Consequently, the Goldstone Report's many legal findings that Israel failed to properly distinguish civilian and civilian objects are inherently invalid. Now, if I had more time tonight, I would go through a similar analysis in regard to the principle of proportionality, which requires that military operations be proportionate. In more formal language, that means that combatants must refrain from attacks in which expected harm to civilians and civilian objects will be clearly excessive in relation to anticipated military advantage. Once again, the main point is, to draw any legal conclusions, you have to know something about rules of engagement. You have to know what the fighters saw, what their options were, what was reasonable in those circumstances. Goldstone had none of that information. He should have not reached, therefore, any legal judgments. Now, my final point, fourth point, about fundamental and fatal flaws. And this point seems to be almost entirely missed in the international community. The Goldstone Report, the undertaking itself, lacked proper foundations in international law, and it lacked proper foundations in two ways. The first way in which the Goldstone Report lacked proper legal foundations has to do with the division of labor between the United Nations General Assembly and the United Nations Security Council. According to the UN Charter, the Security Council has sole responsibility for security in war. In the case of the Goldstone Report, again, which was a creature of the General Assembly, the General Assembly usurped the Security Council's responsibilities. That's because the Security Council had seized itself of the matter of the Gaza operation in 2009. Once it did that under the UN Charter, the General Assembly and its creatures, such as the Human Rights Council, were forbidden from getting involved by issuing recommendations or declarations on the security side. But the General Assembly, through the Human Rights Council, through the Goldstone Report, repeatedly issued legal findings and recommendations about what was to be done through the Goldstone Report. But here is a second and even more important respect in which the Goldstone Report lacked proper legal foundations. I've already alluded to this. Under international law, the primary responsibility for investigating war crimes accusations the primary responsibility lies in the judicial and other relevant organs of sovereign nation states. There are many sources for this principle. You can find it for the scholars out there in the UN Charter, Article 2.7. You can find it in the Fourth Geneva Convention, Article 146. You can find it in 17th article of the Rome Statute on the principle of complementarity. But the main point is this. These very important provisions, documents, international law, all make the same point. They assign to states with able and willing judicial systems the right and primary responsibility to investigate war crimes allegations against them. The leading example of a state with an able and willing judicial system, the leading examples are liberal democracies, which take the international laws of war with great seriousness. Only when a nation state proves itself unable or willing to investigate and prosecute war crimes allegations are international bodies authorized to undertake investigations and make legal findings. The relevant examples of this happening actually involve Goldstone. They come from the mid-1990s, the genocide in Rwanda and the civil and ethnic wars in the former Yugoslavia. These states, or failed states, Rwanda, former Yugoslavia, were clearly unable and clearly unwilling to investigate war crimes allegations. Therefore, international tribunals were in these cases properly constituted. Yet the Human Rights Council, an organ of the General Assembly, began leveling accusations and preparing an investigation of Israel even before the guns had fell silent in the Gaza operation, treating the case of Israel as a special case different from all other countries. Now, these actions, Goldstone Report, the insistence on special investigation, impaired Israel's effective exercise of its right under the international laws of war to conduct an investigation. And they thwarted Israel's discharge of its responsibility. After all, how could Israel complete an investigation that would be taken seriously after the Goldstone Report had convicted it of war crimes and crimes against humanity in the court of international public opinion? In my view, the Goldstone Report's many and varied flaws confirm the wisdom of the international laws of war assigning primary responsibility to nation states for these investigations. Now, this may seem like it's asking states to be judges in causes in which they're also a party. Doesn't have a state have an interest in finding itself innocent, acquitting itself? Well, as a matter of fact, that's what. Yes, the answer is yes. This is a case in which a judge is party to a cause. But this is international law. International law is an imperfect system of law, and entrusting nation states, especially liberal democracies, is better than the alternative. What's the alternative? Well, the alternative, of course, is a kind of global system of governance. International law assigns primary responsibility to nation states out of the larger liberal tradition, based on the larger liberal tradition's teaching that nation states are the best and most legitimate means of securing peace, preserving political freedom, and exercising authority over individuals. This, of course, as I've already said, is especially true of liberal democracies or constitutional republics. The primacy accorded by international states is bound up with the view that states are likely to be more sober in assessing the laws under which states, all states, should live and the actions of other states than our international organizations, because states must bear the burden of any proposed reform or rule. One reason to prefer the allocation of responsibilities in international law as it currently stands is the baleful example provided by the Goldstone Report. It illustrates that those who are responsible for the operation of international institutions are no less subject to the passions and prejudices that thwart impartial and objective administration of law than are judges and other officials in legal systems in liberal democracies. In fact, in some cases, international officials may be more subject to such passions and prejudices. Goldstone Report is a case in point. Now, holding perpetrators accountable for war crimes is a worthy ambition, but it must not be allowed to obscure the obstacles to designing international institutions capable of impartially and objectively crafting, adjudicating, and enforcing the international laws of war. The obstacles to creating impartial and effective international institutions are formidable. They include the obstacles to creating a kind of global governance, global court system. One, the emergence of a transnational elite with interests and ambitions of its own. Second, the lack among this elite of democratic accountability and national security responsibility. Third, the domination of the General Assembly by authoritarian states. And fourth, the presence among the permanent members of the Security Council of veto-wielding authoritarian states. And fifth, the absence in many cases of agreed-upon authority among the nations of the world for adjudicating and enforcing international law. Some of those who wish to increase the role of international institutions and expand the domain of international law are idealists. They believe that that international law crystallizes humanity's considered judgment about morality and war. They believe that international institutions and the men and women who operate them embody a form of transnational or global governance that somehow operates above the fray of nation-state power politics. And they believe that to advance the cause of international peace and justice, critical judgments about the lawful conduct of war should be taken out of the hands of nation-states and assigned instead to international institutions. Encouraged to embrace such utopian opinions and schemes and to brazenly rewrite international law to advance them comes from powerful trends in American universities and law schools. For more than a generation, professors of law and politics in the United States have been cultivating in their students the view, which animates the Goldstone Report, that critical judgments about the lawful conduct of war should properly, and in the first instance, become the province of international institutions. This view, as I said, is idealistic, and it's idealistic to a fault. It's suited to a world in which all nation-states incline to peace and govern themselves in accordance with liberal and democratic principles. Unfortunately, that's not the world in which we live, nor is it a world we can expect to emerge anytime soon. I offer now just a few closing reflections. In the aftermath of World War II, two great revolutions in military affairs have unfolded. One, much discussed, has been defined by technological innovation. It involves the development of weapons of amazing mobility, precision, and destructive power. The second revolution in military affairs is defined by moral and political ideas. It reflects the democratic tendency to transform political questions into legal questions, a tendency, as I mentioned at the beginning, that Tocqueville noted nearly 200 years ago. The second revolution, this second revolution, is a legal revolution. It has brought the conduct of war under vastly greater legal supervision. It involves, to use a fancy, high-priced word, the juridification of war, bringing war more and more, the decisions that are made in war, under the supervision of lawyers. This legal revolution has accelerated over the last several decades and continues apace. In the West, at least, the juridification of war will not be reversed, certainly not in the short term. And as I said, it has had many beneficial consequences. But it can be managed much better. It can be reformed. In many respects, the juridification of war has made the inherently brutal enterprise of war more humane. At the same time, it has been accompanied by a politicization and idealization of the international laws of war that effectively rewards terrorism and weakens the right of liberal democracies to defend themselves. No cure or corrective to these dangerous developments will succeed that does not give close attention to the education of the next generation of lawyers, scholars, soldiers, and statesmen. The young men and women who will assume responsibility for the preservation and elaboration of the international laws of war must be well educated. In particular, they must be well educated to respect the distinction between politics and law, and to appreciate not only humanitarian responsibility, but also military necessity. Consequently, reforming the international laws of war awaits a major reform of educational affairs. Thank you.